Good evening, everyone. Welcome to the Javed Mofagian Cinema. My name is Am Johal. On behalf of the SFU Woodward's Vancity Office of Community Engagement and the SFU Woodward's Cultural Unit, welcome to the discussion this evening on what does the Insite decision mean, a talk by Monique Pongracic-Speier. This is in partnership with the PHS Community Services Society, and I just wanted to acknowledge the help of Coco Culbertson there and also the Pivot Legal Society and the support of Darcy Bennett in those offices. Prior to introducing the moderator for the evening, just a couple of announcements. Next Wednesday at 7 p.m., there's going to be a discussion, a roundtable discussion on the Canadian economy in the same room from 7 to 9 p.m. And secondly, a couple of weeks ago, we had the passing of Jim Green, who was an immense community advocate, very much one of the champions behind the Woodward's project. There's going to be a public memorial at the Orpheum on Saturday, April the 14th at 1:30 p.m. Moderating the discussion this evening will be Peter McKnight. He's a columnist and member of the editorial board of the Vancouver Sun, a legal analyst for Global National and an adjunct professor in the School of Criminology at Simon Fraser University. Former lawyer, parole officer, and hospital board chair, he holds an undergraduate degree in psychology and advanced degrees in law, philosophy of science, and journalism. Peter writes and speaks on a wide variety of subjects, including law and justice issues, science, social science, philosophy, religion, and ethics. Peter has received numerous awards for his work and was named the 2007 Commentator of the Year by the Jack Webster Foundation. In 2007, Peter became the first and only Canadian named a Templeton Cambridge Fellow in Science and Religion at the University of Cambridge. He was also a Knight Science Fellow at the Massachusetts Institute of Technology in 2004. I ask you to join me in welcoming Peter McKnight.
Well, thank you all very much, and thanks a lot, Am. And it's great to see you all here to talk about this. What's a really important issue, of course, as you all know. Also, both scientifically and legally, an interesting issue. And for those of you who have followed the cases, we noticed that there have been a number of very different decisions by different levels of court. And today we'll be discussing this, the impact of this very interesting decision by the Supreme Court, in which the court essentially ordered the Minister of Justice to grant an exemption under the Controlled Drugs and Substances Act to allow Insite to continue operating. And we are fortunate enough to be able to discuss this with the lawyer who actually represented the plaintiffs in this case. As Am said, Monique Pongracic-Speier is a lawyer with Ethos Law Group. She has argued cases before the Supreme Court of Canada, obviously, as well as through all levels of court in British Columbia and administrative tribunals. She, as I said, represented the plaintiffs in what's known as PHS Community Services and the Attorney General of Canada, otherwise known as the Insite decision. And she represented the plaintiffs who are here today, at least some of them, represented them from the trial level all the way up to the Supreme Court. Monique is also a vice chair of the Canadian Bar Association's International Law section, and she actually began her academic career right here at SFU, where she received a BA in philosophy and political science, and then went on to get a law degree from University of British Columbia in 2001. So without further ado, please join me in welcoming Monique Pongracic-Speier.
Thank you very much, Peter. And thank you, everyone, for coming out tonight on what is truly a horrible night outside. I appreciate your presence here, and I appreciate the opportunity to talk about this case. And I propose to address the significance of the case in 3 different ways. First, though, because I think it's not really possible to understand the decision in any meaningful way without understanding the background to the case, I am going to spend a little bit of time talking about how the case got to court, and then I will go through the decisions that have been made in the case, focusing most of all on the Supreme Court of Canada. And then I'd like to examine the Supreme Court's decision from 3 different perspectives. First, I'll talk about what I think the decision signifies for the Insite supervised injection site specifically. Second, I would like to talk about what the decision may mean to efforts to introduce other supervised consumption sites or services, whether in Vancouver or elsewhere in Canada. And then third, I'd like to take a little bit of time to talk about what the decision may mean to broader efforts to change or reform Canadian drug policy more generally, and the way that we respond to the challenges of illicit drug use and injection in our communities. So I'll start then with talking about how the case arose. And I'd like to start with a little anecdote. As Peter mentioned, I went to undergraduate school at Simon Fraser, and I went in the early 90s, and at that time, most of the university's activities were up on the hill on Burnaby Mountain. And I always seemed to draw a night class, every single semester. And I lived in Kitts at the time, so typically once a week, I would need to get the number 135 bus from the hill to the Kootenay Loop. And then I would take the number 14 Hastings, down Hastings Street, and then up to Broadway in Kitsilano when I lived. And I was typically traveling after 10 o'clock at night. And the 14 Hastings, of course, went right down Hastings Street and through the chaos that often prevailed at that time in the 3 to 4 blocks on either side of the intersection of Main and Hastings. When I think back to that time from what I saw as I was riding home on the bus at night, really the images that come to mind are ones of people milling around on the sidewalk somewhat aimlessly, a lot of police cars, a lot of ambulance sirens, and then as the bus passed by the alleys, you could actually see people slumped over in the alleys, sometimes propped up against dumpsters, sometimes just sitting in a heap, and the occasional person who would be in full-blown cocaine psychosis. So the downtown east side of the early to mid-1990s was truly a community in crisis. Roughly half of all of the injection drug users in Vancouver lived within about a 10-block radius of Main and Hastings. That was probably somewhere between, let's say, about 4,500 and 7,000 people. The drug scene in the neighborhood was open, and it flourished, and it caused truly terrible human consequences. For example, between 1998 and 1993, there was an 800% increase in the number of fatal overdoses in British Columbia as a whole. Over half of those were in the downtown east side of Vancouver. It came to be known as an overdose epidemic, and it was characterized that way by a coroner at the time, Coroner Vince Kane, who in a landmark 1994 report remarked on this phenomenon and also tried to look at the causes for it. And he found that they were multifactorial, but that 2 were especially important. One was the rise in cocaine use among injection drug users in the downtown east side. Prior to the late 80s, the most prevalent drug was heroin, but this started to change in the late 80s. And then in addition to that, the drugs on the market were typically of unknown purity and potency, so they could be downright dangerous. Now, the deaths in the community did not go unremarked by the people who lived in the neighborhood. And it's a tribute, I think, in part to them that they were able to transform their outrage and their grief into activism. And through political action, community organizations and committed individuals in the downtown east side drew public attention to the problem. One example of such an action is shown here in this picture. And this was an event, I guess is the way to characterize it, that took place in Oppenheimer Park when activists planted 1,200 crosses into the ground to mark the lives and the deaths of those who had perished from drug overdose in the downtown east side. Now, while the community was expressing its disappointment and its grief at what was happening, public health officials also recognized that it was imperative to get a handle on the public consequences, the public health consequences of injection drug use in the neighborhood. So they started to study the problem in a fairly systematic way. And in 1996, Vancouver's medical health officer, Dr. Elizabeth Wynot, released a report describing the major impacts of injection drug use on the healthcare system in Vancouver. And what she found is basically listed here in this slide, that injection drug use was leading to increased incidences of infectious diseases and also serious deep tissue infections such as endocarditis and septicemia. There was a real problem with fetal exposure to illicit drugs. Injection drug use was also associated with worsening consequences for people with serious mental illness. And Dr. Wynot found that injection drug use in the community was taxing the hospital system, community medical resources, and also emergency services. The level of resources required to try and provide health care to injection drug users in the downtown east side was having a significant impact upon healthcare budgets. The next critical landmark, in my view, is 1997. And in that year, the BC Centre for Excellence in HIV/AIDS and Dr. Stephanie Strathdy in particular announced the results of work that they were doing, which showed that there was a 27% prevalence rate for HIV in the neighborhood. That's an epidemic level. And the publication of that research led to Dr. John Blatherwick's announcement in September of '97 that there was a public health emergency in the downtown east side. So from 97 to 99, there were efforts to try and address the consequences of injection drug use in the neighborhood. And in 99, the health board, the Vancouver Richmond Health Board at the time, undertook another systemic evaluation of public health in the neighborhood. And unfortunately, the results were not at all hopeful. What was found was that population health had actually deteriorated in the 2 years since the epidemic had been announced. Poverty, radically inadequate housing, lack of access to toilets and hand-washing facilities, and social dislocation, particularly for seriously mentally ill people, and also for Aboriginal people who had, for whatever reason, lost links with home communities outside of Vancouver, were suffering from terrible social dislocation. There was a very high rate of malnutrition and a lack of food security in the neighborhood. And we must remember that in the 1980s and 90s, Vancouver saw the closure of addiction services, not their expansion. And that, combined with the lack of access to clean needles, had combined with all of these other factors to create a compound health crisis. And some of the other aspects of that were a transferable tuberculosis epidemic, and this was due in part to compromised immune systems that often come with chronic injection drug use. There was a serious syphilis outbreak among female drug injectors who often use survival sex work to support their addictions. And there were outbreaks of hepatitis A and B and a hepatitis C epidemic, which saw nearly 90% of injection drug users afflicted with that very serious virus. And then on top of all of that, the overdose epidemic still continued. It did not abate very much in the late 90s. So the public health authorities came to the conclusion that it was necessary to address injection drug use in the neighborhood if there was going to be any hope of actually addressing these other epidemic and crisis level problems. So to its credit, the Vancouver-Richmond Health Board acknowledged that the primary epidemic at the root of all of these other emergencies was injection drug use, and that it was necessary to find an effective way to deal with it. And the Health Board decided that its best option in this regard was to introduce harm reduction strategies. And harm reduction is basically an approach to addiction that acknowledges the benefits of engaging with drug users while they have active habits. It acknowledges that prevention of drug addiction is important. It acknowledges that treatment is important. It also says, yes, we understand that there is reason to have enforcement mechanisms to reduce the supply of illicit drugs in the community. But it says, look, people will continue to use until they can get into a position to go into recovery and try and achieve abstinence. We have to address people's needs with where they're at when they're using. And harm reduction was an approach to injection drug use that was somewhat controversial in the 1990s, but it gained political support, particularly in respect of the downtown east side. And here are the essential features of that. In 2000, the federal, provincial, and the city government entered into something called the Vancouver Agreement, which provided funding for the critical matters that were facing the city. And one of the top matters on the list was the injection drug crisis in the downtown east side. So the Vancouver Agreement started to flow some funding for the expansion of harm reduction measures. In addition to that, a year later in 2001, the City of Vancouver introduced its drug policy based on 4 pillars: prevention, treatment, harm reduction, and enforcement. And this policy was introduced in consultation with both the Health Board as well as the Vancouver Police Department. So there was already significant cooperation among the relevant government agencies at this time. And it contemplated the opening of a supervised consumption site in the downtown east side. And then around the same time, the directors of the Vancouver-Richmond Health Board voted to support a supervised injection site. This was done at the last meeting of the Vancouver-Richmond Health Board, and then through legislative change in the province, that was morphed into the Vancouver Coastal Health Authority. The Coastal Health Authority picked up where the old Health Board left off. And to make a long story short, by 2003, the officials at the Health Authority had submitted an application to the Federal Minister of Health for an exemption from the Controlled Drugs and Substances Act to operate a medically supervised injection site in the downtown east side. And it's at this point in Insite's story that the legal issues start to become more important. So I'm going to try your patience a little bit and talk a little bit about Canadian federalism. It's important for the case. Under Canada's federal structure, the delivery of healthcare and social welfare services in the provinces is a provincial responsibility. It's an area where the province has exclusive jurisdiction. And it includes, for example, powers over the establishment and regulation of hospitals and health clinics, the delivery of treatment for addiction, and the regulation of the medical professions. Now, in British Columbia, many of these responsibilities, not all of them, are delegated to the health authorities like Vancouver Coastal Health. So that's the provincial side of the equation. The federal side of the equation is exclusive jurisdiction over the criminal law. And the control of drugs, both illicit, so things like heroin and cocaine, and also licit, things like painkillers that are commonly used for medical treatment, is within the federal government's exclusive power. So that explains why the health authority had to apply for this exemption in order to operate Insite. And the Controlled Drugs and Substances Act is the federal legislation, part of our criminal law, that, for example, makes possession and trafficking and importation and production criminal offenses. But in addition to setting out the criminal offenses and the penalties for them, the Act also contains provisions that allow the federal Minister of Health to grant an exemption from any or all parts of the Act if, in the opinion of the Minister, the exemption is necessary for a medical or scientific purpose or would otherwise be in the public interest. And that's a quote from the Act. So when the health authority committed to open a supervised injection facility in the downtown east side, it sought an exemption from the simple possession offense in the Controlled Drugs and Substances Act, and to a more limited extent, an exemption from the trafficking offense. And I'll just explain briefly how this works. So the possession offense would normally criminalize the possession of drugs everywhere. And so a person coming into the site to supervise under medical injection would, absent an exemption, be liable to an arrest for possession. Those supervising the injection, including the nurses and the doctors, could also be charged with possession. And that's because of the way that possession is defined in the criminal law. And then the trafficking part of it is a more minor piece, but the essence of it is that there was some concern that if staff had to retrieve drugs left behind by clients and then deliver those on to the police, that could be construed as trafficking. So the federal Minister of Health considered the application and granted it. And it was granted on the basis that Insite would be the site of a scientific study about supervised injection. Every injection drug user who used the site was a study subject. And under that rubric, those users would not be liable for possession while they were on site, nor would the staff, and the staff would not be liable for trafficking for delivering the drugs on to police in cases where that were necessary. So that takes us to Insite. This is the Insite logo, and the site was opened in September 2003. It's at 139 Hastings Street, and that's in the block between Main and Carroll. And it was opened on September 21st of 2003. And since then, it has been jointly operated by one of my clients, the PHS Community Services Society, and by Vancouver Coastal Health. And I'll give you kind of a brief synopsis of what happens when a person goes into the site. So an injection drug user will come into the site in possession of the drugs that he or she intends to inject. So they're bought through the normal illegal means out on the street. And the person comes into the site and goes up to a reception desk and registers there. And the person will also advise the staff of what it is that he or she is injecting. This is important, among other reasons, so that if there's an overdose, the staff know how to treat it. Now, when there is room available in the injection room, which you'll see here, the person's admitted into the injection room, and the carrels that are around the wall look like study carrels. They're the injection places, and the drug user will have an injection kit that has all sterile equipment. It's the only equipment that can be used on site, and it's left on site. and the person will prepare his or her drugs and then inject under the supervision of paramedical staff and nurses. And the mirrors that you can see in the slide there are there for two reasons. One, so that the person who's injecting can see what's going on behind him or her. But the other reason is so that the staff people can monitor what's happening for the injection drug user. So if somebody seems to start to slump or nod, or it looks like their respiration rate is going down, all of that can be monitored. And in the case of overdose, there is a medical response. I think at one of the most fundamental levels, it's a testament to Insite's success that nobody has died there, ever. And they've dealt with hundreds of overdoses that out on the street would have been fatal. So let's assume somebody completes their injection and there's no overdose. Then the next stop in the site may be in a clinic treatment room, which is just beyond this injection room. And the nurses at the site provide basic medical care, because many injection drug users, particularly those who are living in very marginal housing or on the street, may have foot wounds, they may have abscesses, there may be other chronic medical conditions that need to be attended to, and so they can get some of that health care on site. For more complicated cases, the person is referred on to other resources. And then the final stop in the site is called the chill-out room. And the chill-out room is one of the key innovations of Insite, which is quite different from how I understand other supervised injection sites work elsewhere in the world. In the chill-out room, the person can just hang out for a while. And there are peer counselors there, and there are also addiction counselors there. So if somebody has been having problems with injecting, for example, or seems to have a lot of abscesses, they might receive some counseling on how to inject more safely. If the person has decided, this is it, I don't want to do this again, I want to try detox, there's on-demand referral from the chill-out room to on-site, which is actually above Insite, and that's a detox facility where people typically stay for 10 to 14 days and then they get referred on to other treatment. And then from the chill-out room, if the person's not going to Insite or to on-site, then the user goes back out into the street and resumes his or her day. So that's basically the way that the site works. Now, you might recall that in 2003, the federal government in power was a Liberal government, so they granted the exemption. But that government was replaced by the minority Conservative government in January of 2006, and I think it is fair to say that the Liberals and the Conservatives had different approaches to drug policy. Now, Insite's exemption was due to expire on September 12, 2006. And prior to that time, the Health Authority did apply to the Minister of Health for an extension. It was granted on September 11, 2006, so one day before the exemption was due to expire. It was subsequently extended to the end of 2007 and then one more time to January of 2008. And essentially, these were just continuations of the same exemption. The rationale that the minister made for simply continuing the scientific study exemption rather than granting a permanent exemption was that the site needed more scientific study. Now, this is a bit hard to swallow, I think, if one understands that for the first 3 years of the site's existence, the federal government made a grant of $1.5 million to study the outcomes of the project. And there was also other money. And the BC Centre for Excellence in HIV/AIDS undertook extensive study of many, many outcomes for the site, looking at its impact on crime, looking at disease prevention, looking at its impact on common conditions like abscesses, etc. But the minister decided that he desired more, so he appointed an expert advisory committee to review the studies. And essentially, to make a long story short, the expert advisory committee had some minor quibbles with certain research methodology, but pointed out that the science supported that Insite was effective to benign on a number of indicators and certainly was not doing any harm. Nonetheless, the attitude that Ottawa had towards the site might be described as unenthusiastic. And by the summer of 2007, my clients became concerned that the exemption was not going to be extended, but it would just quietly be allowed to die, quietly from the federal side, not from my client's side. And so they felt that this was intolerable and that it was necessary to take action. So here's the action. They filed a constitutional lawsuit against Canada in August of 2007, and it was filed by the PHS Community Services Society and two individuals who were at that time active injection drug users, Mr. Dean Wilson and Ms. Shelley Tomic. And I just want to publicly express that I think this community owes them a debt of gratitude for being willing to become plaintiffs in such a high-profile suit. Thank you. Now, this was actually the second suit that had been filed. In the summer of 2006, when it looked like the exemption might not be extended or replaced with a permanent exemption, the Vancouver Area Network of Drug Users had also filed a suit. And it was not necessary to proceed with that right away in light of the extension of the exemption. But once this suit was filed, the two of them proceeded together through the court system. So that leads me to the court decisions. The trial in these actions was heard in late April of 2008, was heard before Mr. Justice Pitfield of the BC Supreme Court. He released his decision inside of a month. In fact, I was somewhat astonished when I heard the decision had been released. I was actually walking up, I think it was Howe Street. I was with a friend. We had gone for lunch. And I happened to run into Joe Arve, who was senior counsel on this case. And he rolled right up to me, and he said, "We won." I said, "What did we win?" He said, "The case, we won." So it was remarkably fast, and it was a strong decision. And we had pursued two lines of argument at trial. And again, this goes back to the Canadian federalism that I tried you with a bit earlier. The first line of argument was that Insite is a healthcare facility that provides healthcare services and that it's under the exclusive jurisdiction of the province. We argued that the application of the possession and, to a lesser extent, the trafficking provisions of the Controlled Drugs and Substances Act to supervised injection at Insite threatened to undermine the provision of these health care services. And we urged the court to apply a constitutional doctrine called interjurisdictional immunity. And the idea behind that doctrine is that when one level of government, say the provincial level of government, exercises its exclusive powers in an area that is core to those powers, so for example, core to the provincial delivery over health care, and a law of the other level of government, so in this case the federal government's criminal law, would threaten to completely undermine the exercise of provincial jurisdiction, then the doctrine goes, the level of government that is under threat should receive immunity or a shield from the application of the other level of government's law. So we argued that in this case, if Controlled Drugs and Substances Act applied to supervised injection, it would essentially vitiate what was being done at Insite, because supervised injection is at the core of the healthcare services delivered there. So that was our federalism argument based on the division of powers. And our second line of argument was under the Charter of Rights and Freedoms. And we argued that the application of the possession and trafficking offenses to users' self-injection at Insite, so in other words, if they were liable to arrest for simple possession, that would constitute a breach of their rights to life, liberty, and security of the person, and a breach of their right not to be deprived thereof except in accordance with the principles of fundamental justice. And that is protected by Section 7 of the Canadian Charter of Rights and Freedoms. We lost on the interjurisdictional immunity argument at trial, but we won on the Charter of Rights and Freedoms argument. And the court found that all of the rights to life, liberty, and security of the person were engaged by both the application of the possession offense and the trafficking offense to supervised injection at Insite. And the court found that the possession offense, for example, which applies, quote, for every purpose without discrimination or differentiation in its effects, unquote, is an arbitrary law that contributes to the very harm it seeks to prevent. And the court also found that the same reasoning applied to the trafficking provision. The remedy that was granted was to send the law back to Parliament to revise it, to bring it into compliance with the Charter. And in the meantime, the site was granted a constitutional exemption to continue its operation on the same terms as it had since 2003. The exemption was granted until the matter had been heard and disposed of by the courts. Well, the exemption was granted. So let's move on to some of the key parts of the decision. The court quoted from the expert advisory committee's report to the federal health minister in pointing out some of the salient features of the community that Insite was serving. And you can see them here on the slide. The long and the short of it is that Insite was serving a community of people who were really marginalized, suffering under burdens of disease and extreme poverty. And so, since the slide is there, I won't go through those in detail. Mr. Justice Pitfield also made three very important findings of fact that track right up to the decision of the Supreme Court of Canada. And so it's worthwhile noting those. And they did not hear back from the minister before Mr. Justice Pitfield released his decision. In fact, they heard back in December of 2008, and at that time, the minister said that no exemption was required, or he didn't need to consider the application in light of the court's decision. But 2 days after the court made its decision, and just before the government announced that it would appeal, Minister of Health Tony Clement appeared before the House of Commons Committee on Health. And there he took the gloves off. He made it very, very clear that he was not in favor of Insite. He called it, quote, a failure of public policy, and also said that supervised injection is not medicine. Later on that summer, he attended a meeting of the World Health Organization in Mexico City and said that Insite was an abomination, and you can put that on YouTube, if I recall correctly. And then he attended the Canadian Medical Association's annual convention and told the physicians present that he questioned their ethics if they believed in or practiced harm reduction. So there was a very strong political statement over the summer of 2008 in terms of how that particular minister viewed Insite. The appeal trundled on, all the materials were filed, and the British Columbia Court of Appeal heard the case in April of 2009, rendered judgment in January of 2010. In brief, the Court of Appeal upheld the charter finding, although on slightly different grounds from the BC Supreme Court. And it also reversed the BC Supreme Court's jurisdiction in respect of the interjurisdictional immunity finding. And two members of the three-person panel at the Court of Appeal opined that if there was any case where interjurisdictional immunity should apply, this was it. So the Government of Canada, not liking this result, appealed on to the Supreme Court of Canada. So here we go at the Supreme Court. And these are Mr. Wilson and Ms. Tomic standing in front of the Supreme Court building the day of the hearing on May 12, 2011. It was a beautiful day for a court case. As you can see, we had sunny skies. And it was quite a remarkable hearing because in addition to the parties to the matter, there were 14 interveners. And they included a number of health or public health organizations that were there to explain to the court why, in their view, supervised injection was medically necessary and sound as a public health strategy. Judgment from the Supreme Court of Canada came down at the end of September, September 30th, I think, 2011. It was a very memorable morning for all of us. We heard, I think it was 2 or 3 days ahead of time, that the decision was coming down, and there were a number of us who thought, what could they have agreed on so quickly? So there was a little bit of trepidation. And of course, the Supreme Court releases its decisions on Eastern Standard Time. So when they're releasing a decision at 9:45 in Ottawa, it means you've got to be up at 6:45 to find out the result of your case. So on September 30th, I went down to Insite at 6:30 in the morning, and this was the site outside of the site. There was a large crowd of people. There was a lot of excitement in the air. And because the site is not actually open for business at 6 in the morning, it operates from 10 to 4, 7 days a week, we were able to receive the results of the decision inside. And I found it kind of comical because this was my first case at the Supreme Court of Canada. I was on my cell phone trying to phone the court registry to find out what the result of the decision was. And I got a busy signal constantly, and I'm thinking, this is my case. How could I not know the result? But fortunately, we live in the age of email and Blackberries, and so as I was on the phone, Mr. Arve got an email from our agent in Ottawa saying that we won. And that was a pretty amazing moment. And I think that this photograph more or less sums up the feeling inside of the site when the decision was announced. But for me, the best part of that morning happened after the hugging was over and the press release was over, and it was time to clean up and actually get out of there so that the site could open for business. And for me, the very best part of that day was knowing that the site was going to be open for business on the 30th, it was going to be open for business on October 1st, and it was going to be open for business every day thereafter for as long as it was needed. And that's because of what the Supreme Court said. So this is another favorite photo of mine, a banner that was hung outside the site, and I think it was there for about a week or two after the decision was released. Excuse me. So let's talk about what the decision said. First, it was a unanimous decision of the 9 justices of the court. This is somewhat unusual in and of itself. In addition to that, it was authored by the Chief Justice. So that's an indicator of quite a strong statement. And what the justices of the court decided is that, unlike what the lower courts had found, the scheme of the act itself, the possession offense and the trafficking offense, were not in and of themselves unconstitutional. The court found that because there was a provision that allowed for the minister to make exemptions, that rendered the scheme of the act constitutional. So what the court did decide is that in refusing an exemption, the Minister of Health had actually offended the rights to life, liberty, and security of the person, of Mr. Wilson and Ms. Tomic, in a way that was arbitrary and grossly disproportionate. And the Supreme Court is not one for economy of words, so this was the best I could do to reproduce a chunk of the case that kind of encapsulates their decision. Now, while you're looking at that, I should point out as a sidebar that when the case was actually being argued before the Supreme Court, one of the arguments that was advanced by the Government of Canada is that the minister had not, in fact, made a decision about the exemption. And the court had before it the transcript from the minister's testimony before the Health Committee of the House of Commons. And several members of the court took the lawyers to the passages in the decision that indicated that Minister Clement was not in favor of the site. And in fact, when the decision came out, the court decided that, in fact, what had happened is that those comments constituted a denial of the exemption. So to remedy what the court found was a breach of the fundamental rights of the plaintiffs in this case, the court granted, or I shouldn't say granted, it ordered, that's what it did, it ordered the Minister of Health to grant the exemption. This is quite an unusual remedy. Normally, when a minister or a decision maker has discretion to do something or to not do something, the court will say, we will leave it to you to exercise that discretion. But in this particular case, the court said the only constitutional choice is to grant the exemption. And as the Chief Justice commented, there would be much to be risked if this was actually sent back to the minister. But I'd also point out that the court found that the exemption was warranted in the special circumstances of this case. So the decision was really fact-specific as to what was happening at Insite in the particular circumstances of the downtown east side. And just for completeness and to wrap it up, I'll also just comment that the court found that the trafficking offense was not really an issue, because if staff members were retrieving drugs and conveying them on to the police, that wouldn't constitute trafficking at law. And significantly, the court overruled the BC Court of Appeal on the interjurisdictional immunity argument. And it found that the case should not be resolved on that basis, and commented that where other options are available, they ought to be used, and also said that the plaintiffs were not able to identify a core to the healthcare power that could be, should have immunization from the reach of federal law. So I'll turn then now to what the decision means or may mean, and I'll begin with the significance of the decision to Insite. Now, the most obvious point is that with the Supreme Court of Canada's decision, the goal that the plaintiffs had of obtaining legal protection for the site was finally achieved. And the court's decision obliging the minister to grant an exemption from the site means that the Controlled Drugs and Substances Act will not pose a barrier to the operation of Insite for so long as the conditions that have prevailed since 2003 continue to prevail in the community. That legal protection was my client's goal in advancing this case, and the Supreme Court delivered on it. But I think there are also several other ways in which the decision is significant. And one of them is the affirmation in no uncertain terms that Insite is a healthcare facility and that supervised injection is a healthcare service. In fact, the court went to pains to point out that this is a strictly regulated healthcare facility, as you'll see in the quote here that I've extracted from the judgment. So it dispels, hopefully once and for all, the notion that what happens at this place is not real healthcare, but is something else. The second comment I'd make about the significance of the decision is that the court quite powerfully affirmed that it is not permissible for government, under the guise of making a policy choice, to use the criminal law to create a threat to health by preventing access to health care. As the as the Chief Justice said here, the minister cannot simply deny an application on the basis of policy simpliciter. Insofar as it affects charter rights, his decision must accord with the principles of fundamental justice. So the Insite decision does affirm that if legislation or political decision-making actually poses a barrier to health care, then the government will be subject to charter scrutiny, and that scrutiny may well lead to a finding, as it did in this case, that there has been a violation of charter rights. And in my view, this is a very important finding for not only those who are coping with addiction, not simply injection drug use, but other forms of addiction, but also for any individual who has a healthcare condition that marginalizes and socially stigmatizes the person. Third, and equally important, the court acknowledged that Insite helps its clients to rebuild dignity that's been eroded by addiction and marginalization. In fact, the Chief Justice quoted directly from Mr. Wilson's evidence in giving her judgment, and I've set it out here in the slide. Now, one could argue that this reference to dignity is simply a rhetorical point. But in my view, it's more than that. It's more than that for two reasons. One is practical. From my understanding and from what I've learned of what happens at Insite, the rebuilding of dignity is probably the most important work that the site does. Because unless a person has some sense that that individual matters and that that individual has self-worth, there's no impetus to take steps to try and escape the struggle of addiction and to say, it is worth it for me to try detox. It's going to be hard, but I am worth it. So from a practical point of view, the affirmation of dignity, I think, is an important affirmation of values and of the value of the healthcare service that the site provides. The other thing is that from a legal perspective, I think the highlighting of dignity in the judgment is important because the concept of dignity is the philosophical golden thread that links all of the fundamental rights that are protected in our Charter of Rights and Freedoms. So it's not insignificant that the court chose to highlight that, in my view. Now, the number one question I'm sure everybody has come in here with is, so what does this mean for establishing other supervised consumption sites? And I think the starting place has to be these comments of the Chief Justice, that the case is not a license for injection drug users to possess drugs wherever and whenever they choose, nor is it an invitation for anyone who so chooses to open a facility, calling it a safe injection site. The result of this case, the Chief Justice pointed out, rests on the trial judge's conclusions that Insite is effective in reducing the risk of death and disease and has no negative impact on the legitimate criminal law objects of the federal government. So I think what we can take away from these comments is that the result in Insite doesn't mean that every supervised consumption facility will or should receive ministerial approval from the federal ground. But I think it also means that not all applications should fail. And to unpack that thought a little bit, I'd like to make 3 points. First, because the court's decision is that the federal criminal law applies in relation to provincial health care facilities that offer this service, any government agency or other organization that desires to open a site will need an exemption. That's going to be a requirement. Second, the court seems to be telegraphing a message with this decision, which I think is sent through the quote that I've set out here, that it would like to see the cooperative federalism that led to the opening of Insite be the rule and not the exception. And I think from my own perspective, from a practical point of view, if other sites are going to be opened for supervised injection or perhaps even for supervised inhalation for crack smokers, it is going to be necessary to have tripartite government support for the project. So I guess my takeaway message in terms of the impact of this decision for other prospective sites is that Insite is not necessarily a silver bullet for other locations, whether here or in other places in Canada. And then this leads me into the third and final area that I want to discuss in assessing the importance of the case, and this is its potential impact on Canadian drug policy more widely. The Supreme Court of Canada has affirmed that those coping with addiction, whatever the root causes of those addictions, do not, by virtue of being addicted, lose their charter rights. The charter applies to people coping with addiction, and it will protect them from government actions that put their lives and their personal security at risk, where those actions are not in accordance with the principles of fundamental justice. The court furthermore demonstrated that it is willing and able to craft remedies that are going to be effective. I often like to think about this case in comparison with the case concerning Mr. Cotter. You might recall Mr. Cotter's case went to the Supreme Court of Canada on the issue of his detention in Cuba and at Guantanamo Bay. And the court found that there had been a charter violation with the involvement of Canadian authorities, but rather than ordering the federal government to seek to have Mr. Cotter returned home, they indicated that the government should do something about the fact that there had been a violation. Contrast that with this case, where here we have a very, very strong and clear remedy through the direction to grant an exemption. So the affirmation that the court has given of the rights of individuals living with addiction and the demonstration of its willingness to actually take action to protect those rights is salubrious. It puts the executive branch of our government on notice that when it is making and implementing drug policy, it must be mindful of the impact of that policy on individual people. And this is a significant check on government power. I also think that the fact that supervised injection has received some degree of constitutional protection through this case demonstrates that this country does value drug policy that aims to assist those dealing with addiction while they're in the grips of it and as a healthcare issue. It affirms one of the essential premises that we advanced at the outset of the case, which is that injection drug use has both a criminal law aspect and a healthcare aspect. And it is neither practical nor desirable to quash either one of those. The duality of it must be recognized. But I think the decision is also not just limited to its demonstration effect for this country or for other countries. In my view, it may also serve as a bulwark against international pressure to pull back from harm reduction practices and to relapse into a war on drugs mentality that has, in my own view, very much failed our communities. Some of you may be aware that the International Narcotics Control Board, which is the United Nations monitoring organ for the implementation of our treaties on illicit drugs, did criticize Canada in its 2011 report for this decision and said that it is not in line with the requirements of the international treaties. There are a couple of things to say about this. The first is that that sort of comment by the International Narcotic Control Board is not a positive statement of international law. It doesn't prove what international law is. But second, and interestingly, I'd also highlight that 10 years ago in 2002, the International Narcotics Control Board itself published a legal opinion indicating that harm reduction strategies, when coupled with supply reduction strategies, were not necessarily inconsistent with treaty obligations. So the Narcotics Control Board has spoken out of both sides of its mouth on this issue. But I think it is to be expected that there will be other nations in the world which will try and pressure Canada from continuing on the course that Vancouver chose and that the Supreme Court of Canada has seen fit to affirm in this particular case. And the final important feature of the decision is that in our country, the Constitution is the supreme law. And to the extent that there is any other law that is inconsistent with that, it yields to the Constitution. So constitutional protection for the result in this case is very important. And I think that with that, it should give some impetus for those who are interested in this issue and those who care about the development of Canadian drug policy to go forward in doing that. It's important to remember that Insite was not the beginning of this episode. It was not even the whole episode. It was the very tail end. And before that, there was social activism, and there were concerned bureaucrats studying the problems, and there was policy making, and there was community dialogue, and all of that led up to a point where we did have a major innovation in our country by opening North America's only supervised injection site. And then we did have to have a fight to keep it open, but the fight worked in the end. And so I'd like to close with this picture, which was taken outside of Insite on the day that the decision released, looking east on Hastings Street. And it's the sunrise. And I think that's kind of an image of hope and possibility that just nature seemed to provide on the day that we got this hopeful decision. And so my takeaway message to you is that if this is something that you care about, then do something about it, and to continue to develop law and policy in a way that will be to the benefit of everyone in our community, including the most marginalized. Thank you.